Okay, folks, time to wake up. We're talking about, we're clean. Richard was our attorney. Raymond and I worked as a part of his team on the case. So it's Ithaca et al. V. Cargill. This is just a schematic that shows the magnitude of the mine that's under our lake. It's over 13,000 acres, 2,500 feet underground. It's been in existence since 1970. However, they've never done an environmental impact statement. And I'm remiss, I forgot to gratefully acknowledge the Cayuga Lake is named after the Cayuga people, and the Haudenosaunee on whose land our structures are built. We just want to acknowledge and give thanks before we do this. So our group was formed when we realized the strange regulatory bedfellows that the DEC and Cargill have become, as evidenced by the stipulation agreement that was signed by them in 2004. Basically, Cargill argued that the DEC doesn't have the statutory or regulatory right to regulate them. The DEC said, well, you know what, we'll agree to disagree. If you give us certain things, we'll just move on in this piecemeal and covert regulatory relationship. So this is a timeline. It shows kind of that this is an old mine. It's been evolving over the years. Cargill bought it for $2.7 million, and the first DEC permit was issued again without an EIS in 1975. So there's one other salt mine in the New York State. It's called Hampton's Corners, owned by American Rock Salt, which is an employee-owned company. They do not, in fact, they recognize the DEC's right to regulate them, so therefore they don't have a stipulation agreement. And they were issued a positive declaration, which, as Richard explained, that means that they must do an environmental impact statement. Again, Cargill argues that they don't. And the one thing is, I also wanted to point out, their EIS documents are available online. They have done similar studies that Cargill has done, they argue are trade secrets. So that's another difference. This is just another schematic showing what the mine looks like, and in the green is a subsidence zone, potentially damage to houses and other structures in that area, and the little shaded area is what it looked like in 1950. This is what it looks like now. You can see there's a link to this gallery, maybe if you want to check it out. So Richard handled some of this. The statute of limitations is short, so all that history I gave you is not subject to judicial review. Segmentation this smells like segmentation, I want to say, but because of the statute of limitations, that was a hard sell. So the DEC, we talked about the hard look standard. Clean decided to take our own hard look. We hired 4 internationally recognized expert geologists, one of whom is here with us today. That's Ray. I'm going to try to hurry up so he can get in a few words. But let's see what's next. So these are some of the risks they identified. Salinization is a big one. And for me, a big one is the climate impacts from the methane gas that is going to be released from the Marcellus Shale and probably not, subject to anyone's review. So Richard talked about segmentation. There's a test for segmentation. Situation seems to hit all of them. Again, there are only certain things we can bring up in our case because it's a limited standard of review and a limited period for statute of limitations. Standard of review is arbitrary and capricious, so as long as they can argue they have a rational basis, the judge doesn't have a lot of leeway to do anything about the situation. So had we brought our case within the statute of limitations in 2015, we probably would have had a better shot at segmentation, because they literally, in 2015, they said, there's no additional surface development associated with this tunnel. And then, boom, in 2016, they've submitted an application for the shaft that connects to the tunnel and the 13,000 acre mine. And again, segmentation, piece by piece by piece. So the catch-22 is that it's funny that at the time, they said the shaft 4 was merely speculative. And they don't share a common purpose because the shaft is for air and the tunnel is for salt? I don't know. So we focused our case on cumulative impacts, which is, you can see it's dealt with in the seeker handbook, but where the DEC is required to take a look at past, present, and reasonably foreseeable future actions, and then assess the cumulative impact. So had they done that, we argue, they couldn't have issued a negative declaration. They would have had to do a positive declaration, and they would have had to do an environmental impact statement. One of the reasons that they need shaft 4, again, if they need it, it makes it more subject to environmental review, is the federal regulations regarding escapeways and refuges. So they claim that they're within compliance. We suspect that there might be some compliance issues there, but again, we don't have access to the mine to figure it out. So our prayer for relief on our case is that the negative declaration be voided, and the negative declaration and the permit approving shaft 4 be voided, and an injunction issued to enjoin further construction until SECRA has been fully complied with. The status update is that we made Richard made oral arguments on the 26th of November, and the decision is still pending, and Cargill is proceeding with blasting, and that's the site, that picture. So a few more minutes for you, right? Here's the forward and back. Thank you.
Good morning, I'm Ray. I'm going to be talking about some of the poorly characterized impacts from salt mining under the lake. And part of the background is that when any project is going forward, let me know if you can't hear. I may need a better mic, but
We can hear you.
Okay, but I can't be heard back there apparently.
No.
So when any project is being proposed, there needs to be a lot of information that needs to be considered.
Oh, that's more.
Yep. There's a lot of information that needs to be considered, and that information needs to be considered by DEC, but it also helps if the public has access to that, the interested public. But before I go on, I want to just emphasize the importance of having this type of three-way dialogue, experts, lawyers, and the citizens who are bringing the issue. This is crucial in any environmental defense action or any time environmental issues are being considered. So salt mining under Cuyahoga Lake, or actually any place, needs to recognize some of these rather obvious facts. First being simply that salt mines are underground empty spaces. And once you have a big underground empty space, it's essentially impossible to keep water from getting into it. That was one of the issues that followed the collapse of the Red Soft mine in Livingston County in 1994. And the possibility of water getting into an underground mine is either from collapse or either from collapse or from gradual leakage. Either way, if you've got a big underground space, it's gradually going to fill with water. And that water, in turn, when we're talking about a salt mine, will dissolve the unmined salt. It goes in as fresh water, but comes back out as fully saturated brine, which is around 20% sodium chloride. At the same time, the weight of the overlying material, the rock and the soil and the water, in this case, where we've got a lake on top, is pushing downward. And all salt mines gradually close up over time. They squeeze closed, not entirely, but more than 50% of that underground void is going to gradually disappear, so to speak. And the overlying ground surface will subside. That's the phenomenon of subsidence. If you've got a lake on top, maybe that's not such a big deal, but in places where you do have mining under land, if you've got buildings whose foundations may be compromised, subsidence can be an issue. But as that is happening, remember we've got now brine in this underground space, and that's going to be squeezed out. And the question of where that ends up is often not addressed, and that's one of the big issues here. So So just in terms of orientation, you've seen this already, understand the geographic context, but on this map here, Ithaca is just a few miles to the south, maybe 2 miles to the south beyond the south border here. And the north end of Cargill Lake, meetings ended late after 40 minutes. Okay, well, what do I do about that? Somebody else can take care of that screen issue.
Is it okay? I
Okay, where? Touch the screen? So in any case, the north end of Lake Montezuma is quite a number of miles northward, but this gives you a sense of the overall setting. And again, here just you get a sense of the pattern of the mine tunnels. It sounds like this may be off as well.
No.
Okay. So anyway, this is the physical setting. You can see the mine tunnels that exist under the lake, and also over to the right, you can see the area under the town of Lansing that was where the earlier mining was done. So essentially all the mining now is progressing northward under the lake, as you can see on the upper left here. So I've talked about this a little bit already. No realistic closure plan, especially the question of what happens to the empty space underground, what happens to the brine that's going to fill that mine. But there are also issues with the thinning bedrock. The bedrock thins toward the north, and also with the more localized thin rock areas, sometimes disturbed rock areas known as anomalies. So that's an issue that needs to be considered but hasn't adequately. And there are also issues with the nearer surface water-bearing zones at the shaft number 4 location is the heart of the current dispute. These are issues of hydraulic communication, in other words, connection with nearby residential wells, and also with Cayuga Lake itself. So I've talked about this pretty much already. Let me just emphasize the last point. If there are brine impacts, and those have not been adequately addressed, but if there are, who takes long-term responsibility? There's a reluctance on the part of government to recognize this, that these are some of the same issues that exist with nuclear waste, another field I'm very familiar with. These are issues that don't just exist for a few years, not just during the period of construction or a few decades. They can extend over decades and centuries. So just to give you a sense of the thinning bedrock over the mine, the concerns include the loss of structural strength. You don't want the mine roof to collapse, as happened with the Red Sox mine in 1994. But there's also the issue of water leakage at various levels, even while the mine is in operation, through thin bedrock into the south. And Cayuga Lake is shown here in blue, and then the lake sits in a bedrock valley, but the water does not extend all the way down to the bottom of the bedrock valley. There are thick layers of sediment underneath. But what is a real concern is that at this cross-section here, this is near the northern extent of the current mining, beyond which they're continuing to go. There's only about an 80-foot separation between the bottom of the bedrock valley and the top of the relatively weak layers of interbedded salt. In other words, the so-called carbonate beam, these relatively strong rock layers, are mostly eroded through at this location. So this is one of the concerns that we don't believe that the thin bedrock has been adequately assessed. And these 5 maps here will give you some different snapshots of what Cargill and DEC have released about the so-called anomalies that accentuate the problem of the salt beds generally rising northward and causing the bedrock separation between the mine roof and the lake to gradually thin northward. We also have these different ovals, one of which, the so-called Frontenac Point anomaly, is actually where there's a fault. The others may or may not have disturbance of the rock, but do exist as relatively thin areas. For some of these, there have been agreements to have a 1,000-foot setback beyond which the mining would not proceed. But for at least one of these anomalies, that setback has not been adhered to. And as I emphasized earlier, it's important to have information available. And we simply have not gotten full or even adequate source of information on what these anomalies are. Why, for example, anomaly C was allowed to be mined under without that setback being adhered to, and so on. So this is part of the problem. I'm saying maps on the previous slide may seem to indicate we're getting a lot of information, but much of the important information including geologic information such as the seismic studies. They actually do echo sounding, so to speak, from boats on the lake to understand what the underground rock structure is. That information and detail is withheld from the public and thus from the experts such as myself who are reviewing this information. So the third of the points is the concern about water-bearing zones at the shaft number 4 location. The pumping test has shown, this is a pumping test done by Cargill's own consultants, has shown a direct hydrologic connection with Cayuga Lake, or an indirect communication with the lake supplied aquifer. And the concern is that the leakage pathway between the lake and the shaft are not well understood and not adequately described in terms of using the studies that have already been done by Cargill and DEC. So the general attitude is that grouting can fix whatever leakage occurs. Again, we don't have enough information to really judge whether that is a valid claim or not. The same concern exists with the upper aquifers, the shallow aquifers that nearby residents use for their drinking water. They may be affected by shaft 4 as well, and again, whether grouting can seal off any connections that are being made remains to be seen. This is just an example of hydrologic connection that was detected back in the 1930s between Seneca Lake and adjacent gas wells. The same sort of concern about hydrologic connection to shaft 4 and Cayuga Lake existed here for these gas wells. Not a big deal because they were abandoned gas wells and they did not provide a path downward to an underground void, such as we're concerned about here. But it's just an example of the water flow pathways, especially at the base of the Onondaga limestone that occurred here and also exist at the Cayuga Lake salt mine. So just a summary of the unresolved issues, no realistic closure plans. What about the brine impacts that have not been looked at? The thinning bedrock, both the general northward thinning and the thin rock areas known as anomalies, and the concerns about the near surface water bearing zones. These are all things that could and should be addressed by seeker, but to date are not. So with that, I'm done. Thank you very much. Is there time for questions?
We have a few minutes.
Okay.
I think one of our next speakers is Mr. Raj, but we're giving you we're going to give you to 5 after 11.
Lead agency status. Do you have any instances where a local government successfully acquired lead agency status on the basis that it itself can hire the necessary expertise needed to properly evaluate a project and its impacts? I raise this because I'm from a town that actively sought lead agency status from DEC itself. Now, on appeal, DEC's determination, this was a mining case, DEC's determination is, oh, we have the expertise, and you don't, you lose. So DEC took lead agency status. I was looking at it from the perspective of having been a DEC attorney, knowing the mine land reclamation program, because I was its attorney. They don't have all the expertise themselves to handle, properly evaluate the environmental impacts. And what they do is they retain outside consultants. So even DEC itself doesn't have all the necessary expertise. This was all disregarded in the appeal, and DEC assumed, lead agency status. It was challenged, the town lost. So I'm looking for any instances where at least there was an assertion by the town that it could hire the expertise needed and therefore acquire lead agency status.
Well, first of all, not everything needs an expert to refute what the agency is saying. It depends on the issue, and certain issues can only be dealt with expert backup, at least to present your best case. And then you pretty much have to go out and hire an expert or find one that will work for you in a modified pro bono basis or pro bono basis. The agency, you're absolutely correct, does not necessarily have the expertise. Also, different departments of the agencies are significantly biased. For example, the mineral division of DEC has never seen a well that they don't think should be drilled. You know, so that's something you have to put up with. And if you're claiming your water's contaminated, they will almost always say it's naturally occurring gas. It has nothing to do with someone's well drilling.
Are you familiar with any instance where the DEC said, you know, you're right, you can't?
I'm having trouble hearing, which is my problem, not yours.
Well, local government, we recognize the fact that you can retain outside consultants, and therefore we give you lead agency status.
I'm sorry, could you?
He wants to know how, if you know of any instances where a town was able to become lead agency when the DEC was claiming lead agency status.
Yeah, the agency that the regulations indicate is supposed to be the lead agency, is the agency that has most control, most jurisdiction over the project. So DEC usually should not step in unless there is cross-jurisdictional issues for the project itself. Clearly, it's rare when someone asks for lead agency status for any other involved agency to also ask for it. It happens occasionally. And then it's up to the DEC commissioner to decide who should be lead agency. I don't know, again, that's rare when that dispute occurs. So I'm not sure off the top of my head of any instances where a town and a state agency like DEC both request a lead agency status and the commissioner decided in favor of the town. On the other hand, I don't know that that does not exist. I think a case could be made, particularly if you're dealing with, let's say, rezoning issues or things of that sort, that the town actually has more expertise in knowing about the land use of their community than the DEC does. And you just have to make that case to the commissioner.
Next question.
I think we do have a little roundtable discussion. We'd like to get on to the next speaker. I did have a quick question. You mentioned that the DEC has to balance economic and social with.
All agencies do,
Yes,
not
they
just
do.
the DEC.
But considering that the DEC has a mining portion and a mineral resources portion, do you have any quick gauge, how they balance that all out?
Because of the case that allowed a lead agency a rule of reason, it's very difficult to, and I don't know of any case that has overturned a project because they've determined that that balancing is not, the court, I don't know of any case where the court based its decision on improper balancing. Courts have said you haven't properly weighed the environmental effects and then overturned the decision. And by the way, that balancing does not apply to the issue of whether or not to do an environmental impact statement. There is no balancing involved, although a lot of times the lead agency will say, well, this is a great project because it's going to create X number of jobs, so we don't have to do an environmental impact statement. That's absolutely improper.
Okay, thank you very much.
Thank you.